Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, I'm going to talk about as kind of a follow-up to a recent video I did on the number one thing you need to do when you get sued by a debt collector. I talked about how 95% of people don't file a written answer with the court and they end up with a default judgment. Well, if you're one of the 95%, this video is for you because we're going to talk about what do you do if you find yourself with a default judgment. And I'm going to give you 3 specific things you can do to try to get that thing dealt with and out of your life for good. But if this is your first time here to my YouTube channel, please click subscribe, check on that bell. That way you'll be notified each week when I put out numerous videos that'll help you deal with your serious debt problem. All right, let's talk about default judgments. As I mentioned in a video that I just put out and in other videos that I have here on my YouTube channel, 95% of people who get sued by a debt collector don't file a written response with the court. Now, there's a lot of different reasons why that happens, but regardless, an answer doesn't get filed and a default judgment gets entered against them. And I can't tell you how many times I hear from people here in my law practice in Arizona who tell me, hey, my wages are getting garnished, or they do a record search, they're trying to buy a house or something like that, and they see that there's a default judgment out there and they weren't even aware of it. Legitimately weren't even aware that somehow this whole legal proceeding went forward without them even being aware of it. Now, often this happens because service of process, where the processor is supposed to bring over the complaint and summons, that doesn't happen appropriately, or maybe they get served through what's called alternative service, where they were just required to drop it in the mail to you. There's a lot of different reasons. I mean, some people do just frankly ignore it. But if that's the case, if you have a default judgment and you're trying to decide what can I do? How can I get rid of that? I want to offer you 3 different solutions on how to deal with it. Now, the first one is you can fight it. If they didn't obtain the default judgment properly, it's entirely possible to get that judgment set aside. And this is even true if the default judgment was entered years ago. I once had a case where the default judgment was more than 10 years old and we were able to get it set aside. Now, the number one way that you're going to be able to get it set aside is if you can show that they did not serve you properly with a complaint in the summons. Now, in every state across the nation, they're required to give you notice of their lawsuit before they can get a default. And typically how that's done is they hire a private process server. Some states use constables, other states use sheriff's deputies, and they're required to bring a copy of the complaint and the summons over and put it in your hand. Now, it's important to note that service can happen by leaving it with other people in your home. Most jurisdictions will allow the process server to leave it with someone who lives with you who's of suitable age and discretion, is what the statute says, or the rule says. And so if they didn't do that first step correctly, then everything else that's followed thereafter is considered void and you can unravel it. And so the way that you have to do this, though, is you have to file a written motion with the court to vacate the default judgment. It's usually done under Rule 60 of your local rules of civil procedure. It may vary in some areas, but most places it's Rule 60. You file that motion with the court and the burden is now on you to show that they didn't serve you properly. So you may be asking, how am I going to do that? The first thing you have to do is go to the court and get a copy of what's called the affidavit of service. Sometimes they call it the certificate of service. This is the document that was filed by the creditor or even the process server, where they're telling the court, hey judge, this is how we served them. We went by their house on this date, at this time, here's the address. In Arizona, they even require them to put a physical description of who it is that they left it with. You need to go get a copy of that and see what it says. Because if you're filing the motion to vacate, it's up to you to provide evidence to show that that was not accurate. Now, here's how you're going to have to do that. If you're going to have to be able to provide something to show the court that either you weren't home or that there's just no way, they had the wrong address. I remember one case we had, the affidavit of service said that they served my client at home. We were able to go to Facebook, of all places, and show that my client was across the country at a wedding on the specific day that they alleged that they served my client personally. That's what you have to do, is kind of come up with some evidence to be able to show that they didn't serve you personally. I can tell you I've had another situation where a client was incarcerated, so we were able to take the records from the jail and show the court, look, there's no way they served my client. My client was incarcerated at the time, had no notice of these lawsuits, and now deserves an opportunity to defend them. If you can prevail on that, so you have to file the motion, you're going to have to let the other side know about it. They're going to be able to come in and object to your motion to set aside. But if you're successful, one important thing to remember is it doesn't dismiss the lawsuit. It does vacate the judgment and it unwinds everything all the way back to right when they filed the lawsuit. They then have to serve you properly and give you a chance to respond. So it doesn't get rid of the lawsuit completely, but often it will give you a lot of leverage to be able to either try to get it settled or at least put you in a better position to contest the underlying allegations in the complaint. So the first one is you can fight it. The second option with the default judgment is you can settle it. You could reach out to the creditor and you can offer an amount less than what it is that they're seeking to collect on. Now, it's important that you do this before they get like a wage garnishment in place or a bank levy. Once those things happen, you lose most leverage and it's unlikely you're going to get a very good deal. But if you can get the judgment, if it's just sitting out there, they haven't collected anything on it, even if it's for years, you can reach out to them and offer to pay 20, 30, 40% of the total balance and get it dealt with that way. Settling is one of the quickest ways to get it dealt with. The downside is you're going to have to pony up some money to be able to get that done. Third option is the nuclear option. It's bankruptcy. Bankruptcy will eliminate most judgments. It'll completely eliminate the debt, it voids the judgment, and they're not able to pursue you anymore on any type of collections. So a lot of it will depend on the amount of the judgment. You know, if this is a $2,000 judgment and you don't have any other debt issues, bankruptcy is not a good option. If it's a $2,000 judgment and it's just kind of the tip of the iceberg and you know that there's a lot of other debt, Chapter 7 bankruptcy may be a great way to deal with this. Get rid of the debt, get rid of the judgment. You won't be facing wage garnishment, bank levy, anything like that. It can be all just dealt with once and for all. Those are your three options if you're dealing with a default judgment from a junk debt buyer or an original creditor. You can fight it, you can settle it, or you can file bankruptcy on it. I hope that's helpful. If you're in the state of Arizona and you need help with something like this, that's what I do all day long. Feel free to contact me below. My information is below the video, and I'm happy to do a free consultation to let you know how you can deal with this serious debt issue. Thanks for watching today.